Good evening, everyone, and thank you for attending. The aim of this session is to provide advice to some of our more long-standing commercial clients. As you know, we're currently in the middle of a challenging economic downturn, over which business owners have little or no control. What we aim to do today is to give you some basic information that may help you through the present difficulties. The focus of my talk tonight is private limited companies. My colleague, Michelle Hardwick, will be leading a similar session for the owners of sole trader businesses on Tuesday of next week. I'd like to start by saying that in an ideal world, hard-working small companies never fail. But as we all know, the harsh reality is that this isn't the case. Despite the best endeavours of its owners, a business can find itself in financial difficulties for a multitude of reasons. What you need to know is what you can do if you find yourself in this situation. As the owner or part owner of a private limited company, most of you will already be aware that your business has its own legal identity as a separate corporate body. Therefore, let me assure you, you don't need to worry about your own personal assets if the business becomes insolvent. However, if you reach the point where your company unavoidably needs to be dissolved, you must ensure this is done in a way which is favourable to its members and stakeholders, including any creditors. You don't want to face legal action due to not complying with this strict requirement. Before we look at the company dissolution process, that is, before you admit defeat, the first thing you should ask yourself is whether there's any way back. In other words, have you considered whether administration could be an option for your business? If you go down this route, an administrator, who is a qualified insolvency practitioner, will be appointed to take over the running of your company, to try and rescue it as a going concern. He or she will also try to achieve a better result for your creditors than would be the case if the company was liquidated, and may even have to realise some of the company's assets in the process. This isn't a pleasant prospect, but it does mean that ultimately your business could be saved and staff redundancies are potentially averted. Let's look now at what the situation is if your business can't be saved. It's important to know that a company can be forced into compulsory liquidation, which happens when the court grants a winding up order, usually at the request of one or more of the company's creditors. In this unfortunate situation, an official receiver will first be appointed by the court to begin the liquidation process, and after that, a liquidator will be appointed. The liquidator will then sell the company's assets and use the proceeds of the sale to pay the creditors in order of priority. This is a costly and stressful position to be in, and one which the members and directors of a company will definitely want to avoid. The best thing to do is act quickly before a creditor can start this process. In other words, if you can see that your business is in dire trouble, the members of the company can take voluntary steps to liquidate it themselves, as long as it's still solvent. This is known as members' voluntary liquidation. But I must stress, your business still needs to be solvent in order for you to start this process. When this isn't possible, because the company is insolvent, its members can choose to go through creditors' voluntary liquidation. In this case, a special resolution has to be passed by the members to dissolve the company, meaning that 75% of the members must agree. And if this is achieved, a liquidator is then nominated. A creditors' meeting will then be convened within 14 days and a liquidator will be appointed who will then start the formal dissolution process. I hope that none of you find yourselves in a position to have to consider these options, but it's always best to be prepared, especially in the current financial climate. Thank you for listening.